6:02, let's go ahead and take a live look at the White House this morning as ABC 15 continues to track the latest reaction after a federal court decided to block President Donald Trump from imposing those sweeping tariffs.
The judge's rulings that Congress has the power to impose tariffs, not the president. We know this could have an impact on Wall Street. We'll be monitoring that once the opening bell happens right around 6:30.
A federal appeals court has ruled that President Donald Trump illegally used emergency powers to impose sweeping tariffs on almost every country on Earth. The ruling from the US Court of Appeals for the Federal Circuit found Trump overstepped his authority under an emergency powers law, a major legal blow that largely upheld a decision made in May by a specialised federal trade court. But the court did not strike the tariffs down immediately, leaving them in place for now and allowing Trump's administration until mid-October to appeal to the Supreme Court. And Trump has vowed to do just that, posting on his social media platform that if it was allowed to stand, the decision would literally destroy the United States of America.
Canada is about to get hit by a trade shock that won't start with a tariff announcement, a negotiation table, or a presidential rally. It will start in a courtroom. The U.S. Supreme Court is moving toward a ruling that could redraw the legal boundaries of American tariff power, especially tariffs justified as emergencies. And depending on what the court decides, the United States could be forced to refund billions in duties, while Washington pivots to new tariff tools that may be even harder to predict, and potentially harsher for Canada. This is not just a legal story. It's a power story. Because Canada's economic fate may soon be shaped by a US constitutional fight Canada didn't initiate, can't influence, and will still have to live with. And that is the quiet theme running through the Canada-US trade war. Canada is rich in resources and capacity, yet structurally exposed, because the levers of rule-making sit elsewhere. To understand what's happening, we need to answer one simple question. Who sued whom, and why? Because this Supreme Court case didn't start with governments at war. It started with American businesses and American states turning on the tariff machine from inside. First came the private companies. They weren't challenging the idea of tariffs in general. They were challenging the way those tariffs were imposed, through executive emergency powers that bypass Congress. One of the most prominent cases came from Learning Resources, a US toy company led by Rick Waldenberg. They sued, arguing that the tariffs were imposed through an unconstitutional use of emergency power. Their claim was straightforward: the president used the International Emergency Economic Powers Act, IEEPA, not for a genuine national emergency, but to pressure foreign governments for political outcomes. In their view, this wasn't national security. It was executive overreach. They weren't alone. Costco sued to secure refunds of duties paid, arguing that if the tariffs are ruled unlawful, the government must return the money. Crocs sued US Customs and multiple federal agencies, seeking tens of millions in refunds and arguing that the president exceeded his authority under IEEPA. Grupo Bimbo, the Mexican multinational, also filed suit, arguing the emergency tool was used to force policy concessions in areas like immigration, something the law was never designed to do. Look at what these cases have in common: they are not moral protests. They are power disputes over money and authority. Businesses want predictability. They want refunds. And they want the rules to be set by Congress, not rewritten through emergency declarations that can appear overnight. Then came the second wave: US states. A coalition of Democratic attorneys general, led by New York's Letitia James, sued on constitutional grounds. Their argument was that these tariffs functioned like massive tax increases imposed without congressional approval. Their focus wasn't just refunds, it was the balance of power. They argued the president had disrupted constitutional limits by using emergency powers as a shortcut for trade policy. So now you have two forces pushing the same question upward. There are private companies saying, this cost us billions and the process was unlawful. Some states are saying, this breaks the constitutional order. That combination is what propelled the issue toward the Supreme Court. And now the Supreme Court must answer a question that sounds technical but carries global consequences. How far can a US president go in using emergency powers to reshape trade? This is where the story becomes dangerous for Canada. At first glance, you might think this is a domestic American dispute, American courts, American law, American politics. But Canada is deeply integrated into the US economic system. So when US tariff authority is questioned or expanded, Canada feels it like an earthquake. Here's the key point, and it needs to be said carefully. Many past US tariff actions included exemptions or carve-outs that Canada benefited from. If the court strikes down certain tariffs, the legal framework that produced those exemptions collapses with it. And that opens the door for Washington to redesign its tariff strategy, potentially using different legal authorities, and potentially without the same protections Canada has relied on. So the risk isn't simply, tariffs go away. The risk is volatility. A ruling could remove one tool and encourage Washington to pick up another, one that is more legally durable and politically aggressive. This is why people describe this moment as the tariff version of the devil you know versus the devil you don't. If the court upholds the emergency-based tariffs, the precedent is clear. The president can impose sweeping trade penalties under emergency logic, with limited oversight. Canada remains exposed to sudden, unpredictable action. If the court strikes him down, the White House may pivot, using other authorities and new designs, to avoid legal challenges. That pivot could produce a tariff regime that is more targeted, more strategic, and potentially tougher on Canada than the previous framework. Either way, Canada is stuck inside the blast radius. And this is the deeper liberation lens story. Canada's economic security is being shaped by a legal battle it didn't start, cannot steer, and must still endure. That is what structural dependency looks like in the modern world. It's not just about who has the bigger military. It's about who controls the institutions that define the rules, courts, statutes, executive powers, and the machinery of enforcement. Now layer in the second major development, the upcoming USMCA review. Canada is already heading into what many expect to be a confrontational negotiation environment. If Washington can credibly threaten a new tariff regime, especially one designed to sidestep legal limits, it increases US leverage going into that review. Because then the message becomes, comply on trade terms, or face escalations that can be justified through alternative legal routes. And once tariffs become a bargaining chip, everything becomes negotiable. Dairy access, digital rules, procurement, industrial policy, environmental standards, whatever Washington chooses to frame as fairness, security, or reciprocity. Notice the pattern. This is not one isolated case. It's the convergence of tools, including legal uncertainty, tariff threats, and a looming trade review, all stacking leverage on one side. This is why the Supreme Court case is not just legal. It's geopolitical. The United States has multiple instruments of pressure, political, legal, financial, and economic, that can be deployed together. Canada has fewer. And when those tools are activated at once, Canada's dependency becomes impossible to ignore. Now let's talk about the money, because that's what makes this case explosive. Businesses are preparing for the possibility of refunds if tariffs are struck down, refunds that could be massive. But they are also preparing for the possibility that new tariffs replace the old ones, creating a cycle of instability. Pay duties, sue, refund, redesign, repeat. That instability affects Mexico, Europe, and Asia too. But Canada feels it more intensely because it is so deeply locked into US supply chains, standards, and market access. So as the Supreme Court moves toward a decision, Canada finds itself in a familiar place. It is waiting to see how decisions made in Washington will shape its economic future. This is not what sovereignty looks like. Sovereignty is not just a flag, a parliament, and elections. Economic sovereignty is the ability to plan your future without external veto. And in this system, Canada lives under veto power, because the rules of trade can shift based on US domestic politics, US court interpretation, and US presidential authority. That raises a hard question Canadians don't like to ask out loud. How can a country rich in resources, rich in skills, and rich in exports remain this vulnerable to another country's legal and political decisions? The answer is structural. Canada's wealth does not automatically translate into bargaining power because its economic lifelines run through the United States. Its exports depend on US access. Its supply chains depend on US regulatory direction. Its industries depend on US stability. And now its trade security depends on a US Supreme Court debate about how much power one president can claim over the global economy. That's the real story behind this case. It is not only about tariffs. It's about the architecture of North American power, which is, who decides, who adapts, who pays. And it's a reminder that in the modern world, power doesn't always announce itself with tanks or speeches. Sometimes it arrives through legal doctrines and courtroom rulings, written in technical language, but felt in jobs, prices, and national strategy. As the ruling approaches, Canada will prepare for all outcomes. But preparation is not control. Canada can respond, but it cannot decide. It can react, but it cannot shape. It can negotiate, but it cannot dictate. And that is the lived reality of being a smaller, rich, yet structurally exposed country inside a system dominated by a single, powerful neighbor. This Supreme Court tariff case is the latest chapter in that story. It won't be the last. But it is a moment that exposes the deeper forces shaping Canada-US trade. That is, law as leverage, uncertainty as pressure, and institutions as instruments of power. If you want to see beyond the headlines, watch what happens next, not just in the White House, not just in trade talks, but in the Supreme Court. Because when trade becomes a weapon, the courtroom becomes part of the battlefield. And Canada is on that battlefield, whether it chose it or not. If this deep dive shifted your perspective, share it, subscribe, and stay with us. This is Liberation Lens. We don't follow slogans. We follow structure. See you in the next.